Welcome to the Deep Dive. Today we're looking at a really challenging intersection of history, international law, and the U.S. court system. It's centered on a 2025 Supreme Court case, Republic of Hungary versus Simon. And the background here is incredibly heavy. We're talking about Jewish survivors and the heirs of survivors from the Hungarian Holocaust. They're seeking damages, trying to get some measure of justice for property that was seized by the state and then sold off, liquidated decades ago during World War II.
Right. And our task today is to unpack the, let's call it the legal rule book that decides if these kinds of claims can even be brought in a U.S. court. That rule book is the Foreign Sovereign Immunities Act, the FSIA. It's really the gatekeeper. And this whole case boiled down to one critical issue. How precisely do you have to trace the money from that seized property to commercial activity happening now or recently in the U.S.? The Supreme Court had to decide that tracing question.
Okay, so let's unpack this. We should probably start with the fundamental idea that was sort of challenged here, right? Sovereign immunity.
Exactly. Foreign sovereign immunity. It sounds technical, but it's a really old concept. Historically, you just couldn't sue a foreign government in U.S. courts. Period. They had complete immunity.
Why was that the case? Just diplomatic courtesy.
Pretty much. It was based on international custom, sometimes called grace and comity. Think of it as countries respecting each other's independence to keep foreign relations running smoothly. It avoids, constant diplomatic incidents triggered by lawsuits.
Right, you can see how that would be necessary. But things changed because obviously this case involves suing a foreign government.
They did. The big shift came in 1952. The U.S. adopted what's called the restrictive theory, and this was a major change. It meant courts started drawing a line.
A line between what?
Between a foreign state acting like a government doing public acts, like passing laws, diplomacy, military stuff, and a foreign state acting like a business doing commercial acts.
Okay, so public acts, still immune, but commercial acts, like buying goods or services, taking out loans.
Exactly. For those commercial activities, under the restrictive theory, the foreign state loses its immunity. It can be sued like any other commercial player.
And then Congress stepped in to make this official.
Yeah, in 1976, Congress passed the FSIA, the Foreign Sovereign Immunities Act. It took that restrictive theory and basically wrote it all down into a comprehensive law. The FSIA starts with a baseline rule. Foreign states are presumed immune. So if you want to sue a foreign country in a U.S. court, you, the plaintiff, have the burden. You need to point to a specific exception listed in the FSIA statute that takes away that immunity for your particular case.
No exception, no lawsuit.
Pretty much. If you don't fit into one of those statutory exceptions, the U.S. court doesn't have jurisdiction, it doesn't have the legal power to hear the case at all.
Okay, but wait. Seizing property during a genocide, that sounds like a very public act, a government act, not a commercial one.
Yeah.
So how does that fit with the restrictive theory?
That's where it gets really interesting. You're right. Expropriation, the government taking property, is typically a public act, but Congress created a specific and quite controversial exception for it.
Which is the one at play in this Hungary case.
Precisely. It's Section 1605A3, often called the expropriation exception, and it's a limited departure from the pure restrictive theory because it allows suits based on property seizures, which are usually sovereign governmental actions.
So what does this exception require? What are the tests you have to meet?
There are two key parts. First, the property has to have been taken in violation of international law. This usually covers things like, mass confiscations connected to genocide or war crimes, which is what the Simon plaintiffs alleged happened in Hungary.
Okay, that seems clear enough for this context. What's the second part?
The second part is the tricky one, and it's what the Supreme Court focused on. It's about a connection to the U.S. The original property, and this is crucial, any property exchanged for such property must have a commercial nexus with the United States.
A commercial nexus, meaning?
Meaning that property or the thing it was swapped for has to be present here in the U.S. and connected to some commercial activity that the foreign country is carrying on here.
So let's use an example. If Hungary seized, say, a famous painting during the Holocaust.
Okay.
And then maybe decades later, they sold that exact painting through an art dealer in New York. That would seem to fit, right? The property is here in connection with commerce.
Yes, that scenario would likely fit the exception. The original property itself is present in the U.S. in connection with a commercial activity.
But what if they sold the painting back in the 1940s in Hungary got cash for it, and then just put that cash in their general government bank account.
Ah, now you've hit the core problem in the Simon case. And this exception, by the way, is pretty unique globally. The Supreme Court itself noted that basically no other country has a similar rule limiting sovereign immunity this way. So U.S. courts are kind of out on a limb here.
Which raises the stakes significantly. So, back to the Simon case. The plaintiffs alleged Hungary and its railway, MAV, took vast amounts of property during the Holocaust.
Right. Furniture, jewelry, businesses, bank accounts, you name it. Mass confiscation.
But as we just discussed, that property wasn't like stored in a warehouse. It was sold off almost immediately back in the 1940s.
Exactly. It was liquidated, turned into cash. And then, according to the lawsuit, that cash got commingled into the general funds of the Hungarian government's treasury. Just vanished into the big pot of government money.
Okay, so that leads directly to the legal argument the plaintiffs had to make, this commingling theory. How did they try to connect that 1940s cash to U.S. commerce decades later?
Well, their argument was essentially this. Look, the stolen money went into Hungary's main bank account. Then, much later in the 2000s, Hungary used money from that same general account to do business in the U.S., things like issuing bonds on U.S. markets, maybe buying military equipment from U.S. companies.
So because the original funds touched that general account, any later commercial use of money from that account in the U.S. should count. That was the idea.
That was the argument. They said the later U.S. commercial transactions were sufficiently connected to the original stolen property because the proceeds, however diluted, were once part of the pool of funds used for those transactions.
And importantly, the lower court, the D.C. Circuit Court of Appeals, actually bought that argument, didn't they?
They did. That's a crucial piece of context. The D.C. Circuit looked at the practical reality. They said money is fungible once it's mixed. You can't tell $1 bill from another.
Right.
So they reasoned, if we demand that plaintiffs trace specific molecules of money from a 1940 seizure through decades of government spending into a 2000s bond purchase, well, that's impossible.
It would make the exception useless for cash claims.
Exactly.
Yeah.
The D.C. Circuit worried it would make the expropriation exception a nullity, basically meaningless, anytime the stolen property was sold for cash and mixed into government funds. They felt it would let states escape liability just by laundering the proceeds quickly.
That seems like a very practical, maybe even a justice-oriented way to look at it. But the Supreme Court saw it differently.
Unanimously, right?
Unanimously. Justice Sotomayor wrote the opinion. And the holding was very clear. Alleging that funds were simply commingled, mixed into a general account, is not enough on its own to satisfy that commercial nexus requirement in the FSIA.
So they rejected the whole money is different because it's fungible idea from the lower court.
Pretty much. They said the statute doesn't create a special, easier tracing rule just because the property was exchanged for cash instead of, say, another tangible item. The tracing requirement remains the same.
Did they offer an analogy or something to explain that?
Yes, they did.
Yeah?
They said, imagine the foreign country seizes artwork A. Then they trade artwork A for artwork B. To use the exception, the plaintiff has to trace artwork B to the country's commercial activity in the U.S.
You can't just say, well, artwork A contributed to the country's overall art wealth, and some of that wealth is now funding an art gallery they run commercially in the U.S. No, you need to trace the specific thing received in the exchange, artwork B.
And they apply that same logic strictly to money, even though it gets mixed.
Exactly. They focused hard on the statutory text. Property exchanged for such property. They read exchanged for to require tracing the specific proceeds or the specific item obtained in that swap.
But how do you trace specific money that went into a massive government treasury 40, 50, 60 years ago and has been spent countless times over?
You probably can't, and that's why the court called the plaintiff's commingling theory an attenuated fiction. Meaning the claimed connection was just too thin, too stretched over time, and too many transactions to be believable or legally sufficient. When cash gets mixed into a huge national treasury, used for everything from paying salaries to buying pencils to funding embassies worldwide over decades, the idea that the specific dollars spent on a U.S. bond issue in the 2000s are traceable back to the specific dollars from a 1940s property seizure becomes, in the court's view, legally implausible. It's just too remote.
So the big takeaway here seems to be the court prioritized the literal text of the statute over the practical difficulties faced by plaintiffs trying to recover stolen assets that were turned into cash long ago.
That's a fair summary. They looked at the broader purpose of the FSIA, too. Congress wrote these exceptions narrowly, they argued, precisely because suing foreign governments is diplomatically sensitive.
Right, the whole friction in foreign relations idea.
Exactly. The court said accepting the commingling theory would expand greatly the situations where foreign countries could be hauled into U.S. courts for things they do to sovereigns, acting in their own territory decades ago. They believed Congress didn't intend that. They wanted to avoid provoking other countries into letting their courts hear broad claims against the U.S.
So, for anyone listening who might be following similar cases or has an interest here, the bar remains very high. You need strong evidence linking the specific original proceeds, or whatever they were directly exchanged for, to current U.S. commercial activity. Just showing the money went into the general pot isn't going to cut it anymore.
That's the standard after Simon. And it leads to this really difficult closing thought the court touched upon. They acknowledged the horrific history, the moral imperative even, to seek justice for Holocaust victims.
Right.
But the U.S. government, in its arguments to the court, suggested that sticking strictly to these FSIA limits might actually be better for achieving justice in the long run.
How so? That sounds counterintuitive.
The argument is that if U.S. courts don't become the venue for all these historical claims, it keeps the pressure on the foreign governments themselves, like Hungary in this case, to create their own mechanisms for redress and compensation within their own countries.
So the idea is making it harder to sue in the U.S. forces those countries to deal with their own history domestically.
That's the diplomatic strategy argument. It avoids turning U.S. courts into global claims commissions and pushes responsibility back to where the wrongs occurred.
So that leaves a really profound question for you, the listener, to wrestle with. When we're dealing with these enormous historical injustices, where does the path to justice lie? Is it through expanding the reach of U.S. courts, even if it causes diplomatic friction? Or is it by respecting the legal limits like the FSIA, hoping to pressure foreign nations to finally reckon with their own pasts at home? There's no easy answer there.